This is Never Close the Inquiry with Nick Hagan. Welcome to Never Close the Inquiry, where I aim to demystify the right for the left and the left for the right, where if you come as a conservative, I want you to leave knowing a little bit more about liberals, and if you come as a liberal, I want you to leave knowing a little bit more about conservatives, with the whole idea that over time we'll create better conversations, better relationships, better arguments, and maybe 80 or 90 more steps down the road, a better country. We got Professor Jonas Anderson, University of Utah, S.J. Quinney College of Law.
Yep.
Let's start with this. What do you teach?
I teach a lot of things. The big thing I do is patent law. That's what I'm interested in. It's what I practice in. But I do civil procedure. I do property. I teach IP in the Supreme Court, trade secrets, IP. So a lot of things.
Yeah.
The one constant in my scholarship and also my teaching is patent law.
Okay. And so teaching all those different subjects, this question, is that something that you did? Because University of Utah is not your first law school. Is that similar where you've taught before, where you'd be teaching something in your area of expertise and then something, things like Civ Pro first year classes?
Yeah, I mean, it's pretty typical across the spectrum. So most schools, maybe outside the top 7 schools that are just like elite, don't teach.
Yeah.
They typically ask you to teach what you write on, like patent law,
Right.
and then something in 1L or some kind of required big class somewhere. So not always, but when I was hired by American University, which I was at previously, they knew I was going to teach patent law, and then they said, we need you to teach property. I was like, I've never done that. They said, we don't care.
Figure it out.
That's what you need to teach. And I loved it. I love it now. But that first year, I was like, what's an easement?
Yeah.
So it was like learning on the fly.
That's okay. So that's funny because I did kind of wonder about that. The set of kind of required classes that everyone at every law school is going to take. You're going to take civil procedure. You're going to take con law at some point. You're going to take contracts. You're going to take property. Might take criminal law. So you taught property because that was what they needed?
Yeah.
And initially you're like, dang, I actually really liked my property class.
I mean, there's some theoretical similarities, like why we have property and why we have intellectual property.
Right.
But like the doctrine, there's nothing in property that is anything like intellectual property. So the first class where I'm talking about theory, great. Everything else after that was like, I got to figure this out.
Nice.
But you can do that because 1Ls know nothing.
Right.
And so you're teaching just a week ahead and you look really smart. It's tougher when you're teaching upper level something new because they have some legal background. And so they're a little more skeptical. But first year is like, great, I'll take notes. And
sure. So, fantastic. This is all new.
Yeah.
So actually, let's take a step back from there real quick. What I want to do, so what we're going to talk about today, we're going to talk about basically judges competing for cases, competition between courts. And at first glance, even for me, when I looked at it, I was like, that's pretty that legal. Like we're talking about a niche audience and whatnot. I don't necessarily think it is. I think it's something that everyone should care about. But
good, because I've been saying this for 15 years.
and part of the reason I'm saying that is because having been a bankruptcy lawyer, I have some actual direct experience with this. Yeah. And the bankruptcy stuff you talk about in your article, it's relevant, but you're talking about it from decades ago, whereas it's still going. There's some very big stuff that's happened in the last 10 years. But before we get to that, I like. Before we establish why people should care about what we're talking about, I want to establish kind of why they should care about you. I want them to have an idea of who you are, So cause we actually have some similarities that I think are kind of fun and maybe don't reflect quite as well on me for reasons we'll get to in a minute. But you are from Utah.
Yes. Not born here, but I was raised here.
Okay.
Went to high school here, went to the University of Utah, and then I left, and I've been gone since then.
Hold on, pause. Okay, wait. Where were you born?
I was born in Texas.
Okay, you're born in Texas. How old were you when you moved here?
3.
Okay. I was
So-
1 when we moved
Oh,
here.
really?
Okay.
Yeah.
So yeah, born in San Francisco.
Great.
Where'd you go to high school?
East Side, right here.
East Side, baby.
Yep.
East Side.
Same high school.
Class of 2008. There
Yep.
we go.
Yep. And then I went to the University of Utah,
Where you majored in.
physics and creative writing.
Right. Okay. So that was what I started out doing.
Really?
Yeah.
Oh.
I started out majoring in physics, minoring in creative writing, and then
Really?
yeah.
Oh, wow.
And that, yeah, I told you.
Yeah.
And here's where it stops reflecting as well on me, because I think that's the best combination you could basically possibly have for anything, for an undergraduate degree. I was going through a stretch where, I don't know, mentally and emotionally, I wasn't quite in the place, we'll say, maybe I am now, or that I was later. Anyway, skipped a lot of classes, didn't do quite so well in the physics courses because of that whole, not learning how to do physics.
Right.
And so I ended up flipping them and majored in English, minored in physics.
Okay. All right.
Yeah.
That's good. I also missed a few classes at the U.
It happens.
But yeah, I loved physics. I was planning on being a doctor.
Okay.
That's what I was doing it. And then my junior year, I worked in a hospital, which was great. But I thought, I don't want my whole life to be here. And I think it was a little bit being naive, not knowing that there were other options other than being in a hospital all the time. But I just thought, like, I don't love it. I don't love being around medicine. And so I started looking around. By that time, you're basically done. So I'm going to finish the physics degree. And that's why the creative writing came in. I was just like, something I want to do, is something I'm interested in.
Yeah.
And I think, looking back on it, I didn't know this going in, but I think it helped in my law school applications because they thought, that's a good combination. Like they like the physics, the philosophy, and then the writing. Even though it's creative, it was something I think that they liked.
When you were doing creative writing, what kind of courses were you taking?
It's a long time ago, but I did as many classes as were offered on creative nonfiction.
Okay.
Which is an interesting genre where you can kind of you're telling a story that's factual, but you can kind of not be loose with the facts, but you can change things to tell the story in a different way better than the story actually turned out.
Do you think, okay, so that's interesting. So I've read a bit of your writing.
Yeah.
It is for a law review article, it's engaging.
Oh, thank you. Thank you.
That's certainly not something you could say of every law review article, having read and edited some myself. But do you think that the writing background helped you in law school and then as an attorney and professor?
Definitely. I think it helps more as a professor actually than in law school or as an attorney. Yeah. Just because, as a professor, the great thing about being a professor is you can do what you want. Like you can write about what you want to write about. Yeah. And so that has very much a creative writing aspect to it. Like you choose your topic and then write something good about it. Yeah. And also I'm writing these huge 20,000 word articles that there's a lot of, boredom in writing a civil procedure article, but you can give it a little flavor that have some things. So I think my creative writing is used more in my current job than in my previous job or in law school.
Got it. It's funny you mentioned that. My if he listens to this, because he is a subscriber, my civil procedure professor who also taught evidence, and I took one other J-term course from him. Funniest, best professor I had. Yeah, loved him. Yeah, they're even in the most kind of boring by the numbers areas of the law. There's you can make it interesting. Yeah,
and I will say this for civil procedure and property professors, the advantage of teaching those classes is people come in with low expectations. It's not like con law, where you're like, oh, this is what I came to law school for. Yeah, no one goes to law school for property. I mean, some do, but
hardly
few.
anyone. Yeah,
and so they're like, oh, this is gonna be a drag. So if you make it slightly interesting, they think you're the best professor ever. So
that's brilliant. Yeah, set the expectations low. Yep. Okay, so let's see. And then so you go to law school. You went to Harvard, and then you practiced at Latham. Mm-hmm. Okay. Latham, for those who are not familiar, one of the best law firms in the country and the world. You were in Silicon Valley?
Silicon Valley, yeah.
Okay. Yep. And then after that, you were only there for a couple of years, right? Okay. And then you go and you do a clerkship on the Federal Circuit.
Yep. Okay. It did a 2-year clerkship. My judge only did 2-year clerkships, and he only took people with experience. So I got the clerkship at a law school, and he said, go do something for a year or two, and then come back and do the clerkship. Yeah. Everyone thought it was weird. He's like I don't want to say how old he is. He's an old guy, but still
Not young.
very active on the
Yeah.
bench, takes a full load.
Yeah.
And now a lot of people are mimicking that because I think
Yeah.
judges know that people that come in with experience are much more valuable than someone straight from law school, no matter how smart they are.
Yeah.
They haven't experienced a lawsuit. They don't know what's going on procedurally. So a lot of people do that model now. And I think that 2 years was great because it takes you about 9 months to even figure out what's going on.
Right.
And then that last year, you can really just do good work.
That's okay. So, and we'll get to this in a second. That clerkship, that is a prestigious clerkship, particularly for someone whose interest lies in the area of patent law.
Yeah, and it's kind of I mean, if you're not into patent law, which I don't know why you wouldn't be, but if you're not into patent law, you've probably never heard of it.
Right.
But it is the court that just took the big Trump tariff case.
Right.
So they have a weird smattering of cases, a lot of patent cases. About a third of their docket is patent cases, and the real reason they're famous is patent cases. But they also have a lot of tariff cases, trade cases.
Yeah.
There's some property cases, some Indian rights cases, some tax cases. So they have a weird smattering of things at the court. But the reason people go there is for patent law. And you mentioned the prestige of it. It's actually, other than the Supreme Court, the court with the highest bonus for the clerks because
is it really?
they're so valuable to firms.
Right.
And so it's a great place. I mean, I love my time there. It's a great place to learn about patent law. And I mean, any students listening to this, you should always clerk if you can. Regardless of where it is, it's a great thing to do.
Well, I didn't. Dang.
You missed out.
Yeah.
Well, you haven't yet. You can still go back and do it.
Theoretically, it's possible.
Yeah.
There are two things I want to do. So last kind of personal question. Did you always want to be a professor? Always. Once you got into law, once you went to law school, once you got to Latham, did you want to be a professor?
Yeah. I always knew I wanted to do it. I think before law school, before I even knew I wanted to go to law school.
Okay.
I was a TA at the university for physics, and I really enjoyed it. And I really thought this is something I'd probably enjoy. I'm not sure what I want to teach them, but I always had it in my mind that's something that's good.
This
something I like
fit.
doing.
Yeah.
Yeah.
Nice. Okay. Yeah. So the article, what we're going to talk about is not just court competition for cases. It's really competition at the district court level.
Yeah.
So just as a bit of a preview, I'm going to set this up, and I want you to correct me where I'm wrong. But just so people have a basic understanding of how the United States federal court system works, it does get a little more complicated than this, and
a little technical.
Yeah. But basically, if you have a pyramid, at the top you got the Supreme Court. It's the ultimate appellate court. And then below that, you have the courts of appeal. We have 13 circuits, 1 through 11 are numbered, and 12 is D.C. Those are all geographic. So like the 9th would include, it's headquartered in San Francisco, includes California, most of the western states. Then, here in Utah, we're in the 10th Circuit. Yep. 2nd Circuit is very well known, headquartered in Manhattan. And the 5th Circuit is very well known, headquartered in New Orleans, but then includes Texas.
Right.
And then the federal circuit where you clerked, it's not geographic.
No.
It has to do with specialized areas of the law.
Yeah. So all those specialties I mentioned before, that's the way we get cases. Not from where they're filed, but what they're about.
Right.
Go to there.
Okay. And then below the appellate courts, we have the district courts. And there are 94 judicial districts in the United States. Some states like Utah have 1. Other states like California, Texas, New York have 4.
Yep.
I don't think anyone has more than 4.
No, I don't think so.
Okay.
No.
All right. So with that background, so people have a basic understanding of how the court system works, what's the article about?
Yeah, I mean, I think that explanation is great. Thinking about the pyramid, but even in reverse, if you've ever been sued, you're not an attorney, you've just been sued by somebody, you've gone to what is essentially district court, trial court, right?
Yeah.
That's where you've gone. If you've gone to appellate court, it's rare. It means your case is over and you've had it appealed. If you've gone to the Supreme Court, it's even more rare. You've gone appealed from a decision, and then the Supreme Court has said, yeah, we'll take that case. Right. So if you read the newspaper, you might think the Supreme Court is the only court in the land. It's actually a very small portion of the total cases they hear. all the cases that are heard at the district court level. So, and there's not much scholarship done on district courts because it's not as all-encompassing. If a district court in Utah makes a ruling, it doesn't affect district courts in Texas or Ohio,
Right.
Whereas the Supreme Court does.
Right.
But if you're talking to a trial attorney, they live in district courts. And so part of being a trial attorney is figuring out what's the best case to court to bring the case, right? This is called forum shopping. Very common. A lot of differing opinions about whether forum shopping is good, but there's undeniable that it's there and there's nothing to do about it.
Right.
There's nothing, we can't stop it. So
Yeah.
there's some things we do to cabin your choices. But if I'm suing you for defamation, you said something about me on this podcast I didn't like, I might have a lot of choices of where I sue. I might sue in Utah. I might sue in California. I might sue in New York. And there are a lot of civil procedure doctrines that say, nope, you're limited in where you can sue. But that's what happens. Like you choose the court. What I'm writing about is that forum shopping idea. But the difference is the judges or the courts influence that, right? They try to say like, bring your case to California.
Yeah.
Or don't bring your case to California. And so that's what I think is different. And that's what I've turned judge shopping. It's become a big term.
Yeah.
It encompasses probably more than I think it should now, but that's initially what I wrote about. Judge shopping as opposed to forum shopping. And judge shopping, I think, until 2 years ago, was universally thought of as a bad thing and something we should do away with when we can. So I wrote about this in patent law. We'll talk about why, but I think the original U.S. example is bankruptcy. The more I read, I don't know much about bankruptcy except for this. Bankruptcy was really the original type of case where courts in Delaware sought to bring those cases to Delaware. It wasn't a function of like litigants choosing where to go. It was a judge changing their court, changing the rules of their court in a way that would attract cases to Delaware.
Yeah. That fascinating stuff. And you're absolutely right, bankruptcy. And we'll, I think a bit later in the conversation, get to some of the stuff that I saw. Because what I'll tell you, a little bit now, when you're preparing a large corporation to file for bankruptcy, you do generally have a list of options. Mm-hmm. There are a number of different ways that you can establish venue in a different jurisdiction, and there are some jurisdictions that are they handle the vast majority of large bankruptcies. Right now it's Southern District of New York, it's Delaware, mm-hmm. as it has been for a long time, and then more recently Southern District of Texas, mm-hmm. which is headquartered in Houston. Yep. And we would go through and. Part of what you're looking at is the individual judges, and part of what you're looking at is the way that the circuits have interpreted different areas of bankruptcy law, and we would have these pages-long spreadsheets analyzing, how the different circuits will look at things.
And just to be clear, that happens in all types of law. Like that's
right.
That's forum shopping. That's what attorneys are hired to do, right? So if
you
get hired as my bankruptcy attorney, you better choose the right court, right? If you don't, I'll be super pissed and I might sue you for malpractice. So I'm not talking about forum shopping, but the difference in the judge shopping decision, and this happened in bankruptcy, is that certain judges, certain courts say, all right, this forum shopping's happening. Right. We want to be on the top of that list. We want to change our rules, not because we want to make it more efficient or quicker, but because we want to attract these types of cases to our court.
Okay, so let's understand, what changes they're making and then why they're making them. So first off, what are they doing to bring people in?
Yeah, so I mean, I can talk about bankruptcy, but let me switch to patent law.
Let's go patent.
So patent law, it's a pretty boring area of law. I mean, if you don't know patent law, you don't care about it.
Right.
But it's a huge industry, like a big business. I mean, billions upon billions of dollars are transacted. They're big billion-dollar decisions against companies. So the same thing's happening. If I'm sued for patent infringement, or I'm thinking of suing for patent infringement, I'm looking across the country and saying, where are the best judges? Where's the best law? Where's the best procedure, et cetera? And so this happened in like every other area of law. in the early 2000s, late 1990s, the Eastern District of Texas, which is a very small district, it's Texas, but there are no big cities. The biggest
It's
city,
like East Texas. What
like
is
Beaumont's the biggest town.
Okay.
Now it's the suburb of Dallas, not Dallas, but the suburbs of Dallas that
Okay.
are large cities. So it's not big cities, very rural, not a lot of corporate litigation going on at all. A chief judge there, Chief Judge Ward, decided he wanted patent cases for whatever reason. He'd done one patent case before. That's why he says turned him onto it. But he decided he wanted to attract patent cases. And so he changed the procedural rules. First of all, he had a set of procedural rules just for patent cases, right? So if you're doing a patent case, instead of being stuck with the general procedural rules, you got special ones in the Eastern District of Texas, right? A lot of places did this, Northern California, but Eastern Texas was a weird one to choose. Also, they started, the jury started giving large sums to winners in patent cases. So that attracted them as well. And then over time, they've done something which is very typical of judge shopping, which is they allow you to choose your judge. So the way this happens is very complicated. I won't get into the weeds right now. If you want to, I'd be more than happy to do it. But essentially, if you filed in East Texas, you could choose your judge just from a drop-down menu. Didn't have the judge's name. It had the division or the city where it's filed. But you could choose anyone with no, if you had venue, personal jurisdiction, subject matter jurisdiction, it didn't matter where you filed. And so you could choose your judge. And so by 2015, about 45% of patent cases in the country were heard by one judge. So this is obviously, everyone had made these spreadsheets. Everyone had figured out this is the judge to get. And they all filed in East Texas if they could.
How easy was it to establish jurisdiction there?
It used to be easy because subject matter jurisdictions, patent law, automatic. Personal jurisdiction is pretty easy. The Federal Circuit has made some rulings that say basically if you sell a product in the district, you have personal jurisdiction. And then venue was tied to personal jurisdiction. It was the same analysis. So if you're suing for patent litigation, in most cases, I would say 96% to 97% cases, you could choose any of the 92 districts across the land. So that made it so there was incredible amounts of forum shopping. And also, I should add, should have mentioned this earlier, patent law, unlike bankruptcy, all the cases funnel to one court, the Federal Circuit. Right. So you're not shopping for the appellate law. You're shopping for the district court and the judge in your case. So all those things made patent law especially, and the money, especially influenced by the ability to forum and judge shop. And so the judges knew this, and they've done a lot of things to attract cases beyond just these special rules. They don't grant stays of cases. They don't transfer cases. They're incredibly low in transfer cases. They have pretty brisk schedules for the case, which typically favors plaintiffs.
Can we pause just really quick here just to explain kind of what these things are? So a stay, how would a stay normally operate?
So sorry, it's very technical, but a stay is there are lots of reasons for a stay. The big one in patent law is called the Patent and Trademark Appeal Board. So if I'm challenging even the validity of the patent, I can go back to the PTO and say, try again. So I might have a parallel litigation. One at the PTO where I'm challenging the patent, and one in district court where I'm challenging the validity and the infringement of the patent.
Got it. Okay.
So I might have two going on. I might have a third. The ITC, the International Trade Commission, also adjudicates patents. So I might have three cases going on, and often I do. Now, in that situation, courts and agencies might say, oh, we're going to stay this investigation until this other party rules, and then we'll see what's going on. So Delaware does that a lot. Northern California does that a lot.
And is that a sort of resource thing where it's like, okay, if you're in front of the PTO and they decide this patent isn't valid in the first place, then why do we care about whether you're infringing?
It's a resource thing. It's
Yeah.
also a decision thing. They're going to decide first. So why are we going to keep going and then stop or maybe rule in a different way? So there are a lot of reasons for it.
Yeah.
And there's a lot of discretion given to judges about whether to grant a stay or not grant a stay. But in general, the Eastern District of Texas was the lowest grant rate for stays. So if you ask them for a stay, chances were they were going to say no.
So plaintiffs love this because they're like, we're coming in and we're going to be able to litigate this to the end and get in the work.
And we can start churning up those lawyer fees,
right?
Which is the way to make someone want to settle because you have someone with an ongoing billable rate in the background. And so if you can have 3 litigations going at once, all going pretty fast, that is a lot of incentive.
Just to provide a little color here, I think people probably have an idea of how expensive lawyers are. They're much more expensive, and they're getting more expensive all the time. We're talking,
and patent attorneys and bankruptcy attorneys are like top of the heap.
We're talking like, let's see, I don't want to. Let me say this: for someone of my vintage, had I stayed in New York, and I know this because I've been looking at fee statements. All this is public, so I can. But anyway, we're talking in excess of $1,600 an hour.
Yeah. Yeah,
not a partner. That's like a senior associate.
Yeah, it's like a 5th-year associate. Is charging those kind of rates. So you can imagine that you're just churning up the bill rates, and that attorneys love that.
Oh, it's fantastic.
So if you're a defense attorney or plaintiff's attorney, you love that.
Yep.
But if you're the defendant, a corporation, you hate it because you're Apple or you're Microsoft, and you have just this ongoing billable rates going up, and have this litigation going on that might go your way, might not. And so the instinct is always like, let's just settle with these guys and get out of this thing so we can stop the bleeding.
Yep.
So that's what a stay is.
Yeah.
Transfers are the same thing. Transfers are when I go to the court, there are various ways I can ask them to transfer it to a different court.
Yeah.
In general, when those are requested in Delaware, in California, in Illinois, about 50% are granted. So if I say, look, this is the wrong court, it should be in Alaska, about 50% of the time they'll look at the case and say, yeah, that should be in Alaska.
Yeah.
Eastern Texas, Western Texas, basically say no.
This is a good spot.
Less than 20%, I think it's less than 15 now. So if you get sued in Texas, you're basically stuck there. And that is just a judicial decision not to grant those. And the fact that they don't grant them makes people more willing to come to your district.
Right.
If I really like Delaware, I think all about Delaware says this is the place to litigate. If I look at it and say, well, there's a 50% chance that it gets kicked to somewhere else, whereas if I file in Texas, which isn't as good, I have a great 85% chance we're going to stay there. That might be the tipping point for you.
It's interesting. That was, before we'd file a company for bankruptcy, that was a major thing. We spent a huge amount of time. We were very careful that wherever we went, we had a very clear jurisdictional hook where we knew we weren't going to get transferred. You look like an idiot, and then the cost is enormous.
Yeah, I mean, it's enormous. You litigate about where to litigate,
right?
And the client doesn't understand what are they litigating about.
Why am I paying these guys?
Yeah, and so if you lose that and you're transferred, oftentimes the attorneys lose the case. They just file with a new group of attorneys. So these things are all within the discretion of the judge. I don't want to demean any judges here saying they're making the wrong decisions, but they are definitely in Texas looser with the rules in the sense that they think there's not as much discretion about transferring or staying in case. There's going no matter what. Yeah. And so just that instinct, which we believe, and I think is pretty documented, that the reason they do this is because plaintiffs really like it, and that's going to lead them to file in those districts. We think those type of changes or changes the norms, although they're not illegal, they're not doing anything wrong. We think judges should be agnostic to whether the case comes to them or not, right? Deal with the cases that come in front of you. Don't set things up so that people come to you in certain types of cases.
Yeah. I think we want justice to be blind,
Right.
more or less.
Right.
Justice and justices.
And this is something we might talk about later, but I didn't get much traction when it was just about patent law because everyone said like, well, Apple's fighting Microsoft. I don't care what it is. Like,
Right. Yeah.
in Texas and Delaware, let it go wherever it is.
Yeah.
I think now that it's become political, it's become it has a clear right and left view about the case, and those cases are being judge shopped. Those cases are being placed somewhere.
Yeah.
I tried very hard to fix this problem before it got to that point. I failed on that. So now we're in a world in which judge shopping is something that's commonly known outside of patent law because it infects everything.
Yeah, it would. There's this in a perfect world, we might say that you're going to get the exact same result no matter where you file a case, and that in the real world that is just not the case.
Yeah, and it's never been the case. I mean,
right.
that is. I'm not saying that is a new phenomenon.
Right.
If you were suing about gay marriage early in the gay marriage fight, and you were in Louisiana, you might get a very different result than if you were in Northern California.
Right.
That's just the way it's been. It's unfortunate it's that way, but it's just a reality of the world. But there are a lot of things that can kind of suss that out. The appellate courts, in general, have a broader makeup than the single judge that hears the case the first time. Also, it's going to end up in the Supreme Court anyway. So there's some people that say, like, who cares about the district court? It's going to end up in the Supreme Court. But it does matter. So even the abortion medication cases, which were filed in North Texas with a single judge that they had a 100% chance of getting, he found that the mifepristone, he found that to be he took it off the market, right?
Yeah.
This district court judge. And some people say, well, who cares? It's going to be reviewed by the Fifth Circuit and then by the Supreme Court.
Yeah.
But it does make a difference. Like the journey it takes to get the Supreme Court is very different if you're litigating in North Texas and then going to the Fifth Circuit than if you're litigating in, say, Hawaii, going to the Ninth Circuit.
Right.
So it can be very different ways of litigating. And I'm not trying to say that that's bad or we need to fix that. What I am saying is that choosing your judge that hears the case the first time, that writes the case the first time, that is antithetical to the way American justice is supposed to work. If I can choose my judge, I might know that he is an anti-abortion or pro-abortion judge, which they did know. They knew this judge was an activist before the bench. He was anti-abortion, and he wrote a very anti-abortion opinion, as you might expect.
Right.
That's different than we're going to file in this district. We're going to get a random selection of 1 in 20 judges. We got him.
Yeah.
Right. That's a very different scenario than just choosing that judge, having him write the opinion, and then starting that whole journey.
I had a question right here. Yeah, I thought this was an interesting part of your article. Is when you're talking about the political cases, you quoted Professor Steve Vladeck from.
He's a former colleague of mine.
Oh, is he really?
Yep.
Oh, cool. He's at UT Austin now?
He's at Georgetown now.
He's at Georgetown.
Austin and Georgetown.
Got it. Okay. Where'd you guys teach together?
We were at American University together.
No kidding.
Yeah.
Okay.
We played basketball together. He's a great player. So
right.
You wouldn't know it, but he's a tall guy and he's got a soft, buttery shot.
and now he's pretty prominent commentator.
Yep, he is.
A lot of things. It was interesting though, because he framed this as on the right. There's more judge shopping, on the left, less of it. My impression, I was kind of wondering about an explanation for that, because this is not like people on the left like, oh, justice is blind.
Right.
No, I was wondering if it would be accurate to say or to guess that there are fewer obviously conservative judges than there are liberal judges. And if, for example, I had a political issue, if I'm coming at this from a conservative perspective, I want to get in the Fifth Circuit. Northern District of Texas, fantastic. Get to a Trump appointee there, but I want to be in the Fifth Circuit.
Yep.
And then if I am approaching something from the left, I have more options. I think I want to get if I'm in California, Ninth Circuit,
Mm-hmm.
fantastic. Or any Hawaii, any of the
Yep.
constituent states. Second Circuit, good. DC Circuit, good.
Yep. I think that's fair. I don't think you can say that there are more. There might be more. I don't know the exact numbers, but there
Yeah.
are a good number of both conservative and liberal judges that you can know going in.
Yeah.
So
Okay.
I think the difference. Well, I think there are two main differences, and this is my scholarship. This is more opinion, but this is I think the two main differences. One is timing. Like
Okay.
I think this is a phenomenon that has really arisen in the last 5 years,
Okay.
and so in that time, Trump's been in office for a long time.
Yep.
When Biden was in office, there was more split, and so I think that the Democrats haven't had as many opportunities to judge shop. I think if we leave the system as it is, it's inevitable. Like
Yeah.
they're going to look at this and say, look, we're losing, and so this judge shopping has worked for them. Let's have it work for us. And I
Yeah.
think that is the obvious way this is going to play out.
Yeah.
So the first issue is timing. It's just there's been more opportunities for the right to use or abuse judge shopping than the left.
Okay.
The second thing is more inside baseball, and that is there are more conservative judges in single division courts.
That's huge.
And so why is this the case? It's basically because rural areas are typically more conservative than liberal areas.
Yeah.
So if you're looking at Texas, massive geographic scope, they have a lot of single division, which is one judge. If I file there, I'm guaranteed or nearly guaranteed I get him.
Yeah.
Those single division judges. And those judges, on the whole, tend to be more conservative.
Yeah.
So if you look at Victoria Falls, Texas, very small town, they have a judge. He turns out to be very conservative because the area is very conservative.
Yeah.
Whereas the liberal judges tend to congregate in Chicago and San Francisco and
Right.
New York, and they're in a group of 20 judges. Most of them are liberal, but there are some conservatives mixed in there. So if I
Yeah.
file in that district, I have a pretty good shot of getting
Yeah.
a liberal judge, but I can't guarantee it. Whereas in the conservative areas, I can virtually guarantee it. I can choose, like Judge Kaczmarek. I can choose him
Yeah.
to do my abortion case.
Yeah.
And I think that is really what is the worst uses of judge shopping.
So it's interesting. I want to just add a little additional meat to that from the bankruptcy perspective, and then I want to ask why these judges are doing it. So one of the big reasons over the last 20 years that Delaware, it didn't necessarily lose what was an ascending dominant position in bankruptcy because it still has it. It's one of the big three. But the reason SDNY, I think, kind of reasserted itself, and then certainly Southern District of Texas really came on hot, was because so in Delaware they went to a wheel.
Yeah.
Where if you file, some of the judges are, and I should also explain this, from when you're filing for bankruptcy, we're talking about large corporate debtors. When you represent debtors, and that's what I did, you're looking for judges that really know the law very well, are commercial. They understand that you're a business, you're trying to stay in business, and you're trying to get through bankruptcy as quickly as possible, and they might not they're. I have to be careful how I phrase this, but there are people who look at bankruptcy as a way to right wrongs, and especially if a business is in bankruptcy because of something bad it's done, they want to make sure the little guy's okay, and the bankruptcy code is not really written for that.
Yeah.
And so you're looking for someone who probably whose background is in like debtor practice or something. And
Let me add one there.
Yeah.
I hear that the attorney's fees is a big deal. If the judge will approve your super high attorney's fees,
it doesn't hurt.
turns out to be really important for attorneys.
There's also that. But what happened was so Southern District of Texas, they thought, okay, we're going to start putting something together. They had 2 judges down there, and if you filed in Houston, you knew if your case was over $10 million in debt, which is for the kind of debtors we're talking about, is a very low threshold. You were going to get one of 2 judges, Marvin Isger or David R. Jones. say David R. because there's now a David S. an SDNY, and he probably doesn't want to be associated with the David R. For reasons completely unrelated to his ability as a judge and more to an inappropriate relationship he had with, anyway, he's now not on the bench. But anyway, they were both very good commercial judges who got, they developed their reputation with oil and gas cases. And that's what I did down there in front of Judge Jones. And then they expanded and, a bunch of firms started filing other big cases. Then in New York, this is where it's interesting. You get like the division thing. So Southern District of New York was divided into two divisions. So you had Bowling Green, which is headquartered in Manhattan, Lower Manhattan, and then they had one in White Plains. And in White Plains, there was one judge, and he's a former colleague of mine. He's a good friend. We emailed most recently this week, Bob Drain. Among bankruptcy judges, he's probably the most famous recent bankruptcy judge in the country. He presided over the Purdue case. He is as smart, knowledgeable, and kind a guy as I worked with, brilliant judge, but you knew if you filed in White Plains, you were going to get him. You were not going to go to Southern, to Manhattan and be on this wheel where you might get a great judge, but it's in front of some great judges there, or you might get someone who had less of a track record or who had, less of a background doing debtor work or whatever. And they changed that just in the last few years where everyone's on the wheel now and it changes things.
Yeah, and the wheel is our solution, right?
Right.
We think the wheel for everyone is the way to get rid of these. So if we put all these rural northern district of Texas judges on a wheel and say like, you're going to Victoria Falls or you're going to Dallas.
Yeah.
Right? That's the way to get rid of these judge shopping, choosing your judge for your case. Now, it might not influence, you might still file in northern Texas, but then you're just in front of a random judge. It might be Judge Kazmarek, but it might not.
Right.
So you have to think about that a little more. It makes it so the judge's personality is not the overriding feature, or the judge's style of adjudicating is not the overriding feature. It's the law.
Yeah.
Right? And so that's what we think is the easy fix. It's the fix that the Judicial Conference approved of, and they tried to pass with the judges. The judges pushed back on this because it's now become political.
Yeah.
But I think the wheel is the answer. I mean, the same story you just told about using the wheel to attract cases. This happened in Eastern Texas. Waco did this. Judge Albright attracted all those patent cases because he had all the cases filed in Waco went to him. Yeah. But the opposite happens as well. Eastern District of Virginia, just south of D.C., had a ton of patent cases, and they didn't like them. Like they said, these are too much. They're clogging the docket. And so they said patent cases, and only patent cases, are assigned on the wheel in the district wide. So you might end up in Roanoke. You might end up in Newport News. And that was just to dissuade patent filers. We think this is bad too, right?
Right.
There's no reason you can say like, oh, ERISA cases, they're going to be assigned district-wide, whereas everything else is not. Yeah. We think these manipulations of the assignment system just to get rid of or attract cases is really antithetical to what American justice is supposed to be.
It certainly doesn't make a potential plaintiff feel very good if like the judge doesn't want their case.
Yeah. I mean, that is also a signal of like, we don't want these. If we get them, it's going to be bad.
You had a quote in the article about I think it might have been one of the Texas judges saying he didn't want FELA cases.
Yeah, I think it was Judge Ward where he said like, I don't want these boring insurance cases. I don't want these boring cases. I like patent cases, and that's great if you like patent cases, but not great. 45% of cases in the U.S. that seems a little much.
So So we understand why, from a plaintiff or a corporation's perspective, like it really matters to get in front of a certain judge, and if you can guarantee which judge you're going to be in front of, like that's potentially very valuable, or knowing how you can avoid certain judges. Mm-hmm. But judges, as you point out, like their salaries are fixed, and another, these judges, vast majority of them, could be making much more money not judging. A lot of it, like especially, I mean, this is to have the kind of experience to be nominated as a federal judge or to become a bankruptcy judge typically means that you've either been in private practice and you've been successful. We're often looking at partners from firms, might be looking at law professors. Like, these are people who are going to take a salary cut.
Law professors, I'm not sure. But law professors, partners.
Oh, huge cut.
They're taking like an 80% cut.
Yeah.
So if you're getting into judging, either you really wanted to be a judge,
right,
or there's something else is drawing you than the money. And so a question that they always get from this is like, why do judges do this? They don't make more money doing patent cases. Patent cases are hard. Like, they take a lot of time.
Right.
And so why, and bankruptcy cases the same way.
Yeah.
Why do they try to attract these cases? And I think the answer is they don't, for the most part. Like, 95% of judges don't do this. They wouldn't do this. They don't want patent cases. I mean, Eastern Virginia is a great example. It's like, they don't like patent cases.
Yeah,
they're hard.
It's hard.
Yeah, it's a weird area of law.
Yeah.
But there are a few, Judge Albright, Judge Ward, Judge Gilstrap in East Texas, that do want them. And so and this is a question I get every time. I've written a series of 5 to 6 articles on this.
Yeah.
And the question I always get is like, why would a judge do this?
Right.
And there's not a single answer, I think, for why judges do this, but there are a bunch of potential reasons. So I think it's better to look at specific judges and districts.
Okay.
Eastern Texas.
Yep.
I think Judge Ward just was interested in patent cases and he wanted to get some. Once he got them, he realized, one, they're cool. I want to keep them coming.
Yep.
But also, there is a real economic development story in East Texas. It's not a very urban district. And I had the pleasure of litigating in Marshall, Texas.
Yeah.
Marshall, Texas is a teeny town, very bucolic, lovely town, but it's teeny.
Yeah.
And at the federal courthouse, right in front of the courthouse, they have a ice skating rink donated by Samsung, with Samsung ads all over the place. And that's just because Samsung is always sued in East Texas.
Yeah.
And they want the jury to see that before they walk into the courtroom.
Like, nice ice rink.
They give us this nice ice rink.
Yeah.
And so all of these things say that, and I walk through a bunch of things in other articles, like the amount of scholarships given to East Texas residents from tech corporations is astronomical compared to other regions. And this is just to like curry favor with the jury pool.
Yeah.
If you've ever been to Marshall, like I have, you'll stay in a hotel with just patent attorneys. That's catering to patent attorneys, has conference rooms.
Yeah.
Everything's back in the day, faxes set up for patent attorneys.
Yeah.
They have catering that's specific to people coming from San Francisco or New York. So in that sense, it's really been an economic driver in Texas. So although the judges don't benefit directly from this, their neighbors do, their family does. And there are lots of ways you can benefit from having all these patent attorneys come to your town all throughout the year.
Yeah.
That might entice you to keep those patent cases coming. So one reason is economic development. Now, this doesn't apply to the eastern or the western district of Texas, right? San Antonio, Austin, these towns, this is a drop in the bucket. Like if you say, I have 30 patent attorneys a day coming to your town, it's like, they say, who cares? So it's not that. Judge Albright, he's a different story. He was nominated in 2019 to the bench.
Okay.
He took over the Waco district, single judge. You can just choose him, and he went on an advertising campaign. I met him first time at a law professor conference. And he came and said, "Look, I'm a new judge. I would love to have your patent cases in front of me. Bring them to me. I'll adjudicate them." And so that's actually the first
pretty
time
explicit.
I thought, like, this is rather explicit for him to say that. And so his motivation is different. He's not doing this for economics. I actually think he enjoys these patent cases. He's a patent attorney by trade.
Yeah.
He's dealt with this a lot. I think he's more familiar with these cases. He likes these cases.
Yeah.
If you do patent cases a lot, they're fun.
Yeah.
So he might just like them, but I don't think that's a great reason to change your procedures so you get more patent cases. Because when you change these procedures, change these rules, they have to favor plaintiffs.
Right. Yeah.
That's the reason
It's not that defendants aren't filing.
No.
Right.
So that's the reason you do it. And
Yeah.
if you want to track patent cases, even if it's for something like I like patent cases, the way you do it is make it easier for patent plaintiffs to adjudicate their cases in front of you. That's simply stated. That's what's going on.
Yeah.
And so if that's the reason you're doing it, even though the motivations might be innocuous, what happens is we think a bad thing. And so that I think is another reason they do this. There are a bunch of other reasons we throw out in the paper. One more I'll just highlight. We've seen a lot more in recent years for reasons that you kind of alluded to. Judges make a good salary, maybe $200,000.
Yeah.
But that's peanuts compared to what they make as a partner.
Yeah.
And so a lot of judges nowadays are retiring early, foregoing the benefits of being a retired judge, which is enjoy a full salary and make a ton of money going back to a law firm.
Yeah.
That's a choice you make. But if that's what you're doing, and I don't want to accuse Judge Albright of doing this, but if he was doing it for that reason, we think that's a bad thing. Because again, you're going to favor patent plaintiffs when you do that because you know you're going to be employed by the patent plaintiffs. They're going to pay you a lot of money in the future. And so this applies beyond patent law. This is a problem, I think, with the federal judicial and the federal judicial salaries is that a lot of judges are going back into private practice. So even if they're doing it subconsciously, they might think like, oh, this is someone who might employ me or a law firm that might employ me or a business that might employ me. I should adjudicate this a little softer against them. So that's a bigger problem than
and just to give people an idea of the scale that we're talking about, like you're saying, for a lot of people, it's going to be like an 80% cut. And I think in some markets that's true, but in the big markets, in New York, in DC, in LA, and San Francisco, it's a much bigger cut than that. Where you're making, let's say you're making $200,000 on the bench. I think it's probably not more than that.
Yeah, I think it's less. But
a little bit less. At one of the big law firms, profits per partner is over $5 million, 6, 7. You might, as a former judge, you go in, I'm going to litigate. This person's going to bring in a lot of business. You might go in making 8 figures.
Yeah. And we've actually seen, I don't want to say the exact story, but we've seen a lot of judges in East Texas, which I've talked about a lot, that have retired and then gone into work at patent law firms. So the interesting thing is they go on the bench with no patent experience.
Yeah.
They gain patent experience on the bench and they go to become partners, or oftentimes they're of counsel, but they're well paid of counsel to attract the cases. So the amount of work they're doing is lower than a partner, but they're able to make those kind of money. So, I mean,
not bad.
I don't want to say any judge is doing this, but there's a lot of evidence that this is probably happening. And it's natural. Like if you're looking at $200,000 versus $4 million a year, and you're talking about the same-ish amount of work.
Yeah. That's tough. $4 million is a lot of money. That's pretty good.
Tough to forego.
Yeah, that's interesting. And you highlighted a couple of other reasons I'd want to talk about briefly. It's funny, we're talking about patent law primarily, and then a little bit about bankruptcy. We're talking about areas of the law where, like the big players within those industries, the average person will die having no idea who they are. Any of them are. However, within these little worlds, there certainly, there are, you can get famous. You can get really well known. I could tell you off the top of my head, top 10 bankruptcy lawyers or whatever in New York, and all the judges. And it's because Wall Street Journal will cover things like this, but you also you go to all sorts of conferences, you meet them. And you'll see people are getting awards that kind of got made up, and they deliberate talk, and you go to the fancy dinner, and there's
a celebrity aspect to this.
For sure.
So I mean, all these things are in play. I mean, the celebrity aspect. I mean, you're a patent judge. Who cares? Like, the general guy in the street doesn't know you. But if you're a patent attorney, I guarantee you've heard of Judge Albright. I
Right.
guarantee you've heard of Judge Gilstrap.
Yeah.
Even if you've never litigated in your life, I mean, you know these names. And so
Yeah.
they get invited to speak at my law school and
Yeah.
conferences. And some of these conferences are really nice. In nice
Oh, yeah.
places. They have dinner in the Dallas Cowboys Stadium. I mean,
Yeah.
these are nice events.
Yeah.
They pay for you and they put you up in a hotel.
Yeah.
I mean, you're not going to get rich on this, but it's like, it's a nice way to live, to always be
Yeah.
a celebrity. So that Instagram, everyone's kind of famous. This is legit famous for not being famous, for doing something actual.
For not being famous. No, I'll tell you, just to go back to the Bob Drain example. I remember the first time I saw him at a conference, because it was like, holy crap, that's Bob Drain. He's the only bankruptcy judge I've heard of. This is like right after I joined the group. And then when he joined Skadden after he left the bench, it was a big deal where, the email comes out from the head of the group and everyone's like, oh my gosh.
Yeah.
Like, we got Bob, or it became Bob at that point. It's the Honorable Robert D. Drain, retired.
Yeah, it's funny. I mean, I don't know the relationships these judges have with their firms, but a lot of why they're paid so much money is just to have their name on the firm. So they can go pitch a client and say, like, we want your patent case. And oh, by the way, the former chief judge of the Eastern District of Texas, the court that gets the most patent cases in the world, is sitting down the hall.
Right.
And so a lot of it is just like, I mean, frankly, the reason Supreme Court clerks get such a big bonus is not because they're incredible attorneys, which they probably are.
Yeah.
But it's largely to say, like, oh, hey, IBM, why don't you come with us? We have 3 Supreme Court clerks we can throw on your case.
Yeah.
They might not do anything, but they might. And so that's a big. I mean, if you're talking about the aspect of law firms that attracts judges to them.
Yeah.
It's a big deal. Having celebrity endorsements, essentially, matters.
Yeah, no, you're absolutely right. Thinking back, back to the firm, you look at any firm and it's like a lot of their biggest, litigators and deal lawyers, it'll be people that went to law schools that are fine but not great. They just, they did well and then they worked really hard. But then you'll have these other people that, that have the incredible resumes that clerked to the Supreme Court and got the big bonuses. But you just kind of try, it's good advertising, and then it's these other people that actually do the work.
I mean, you see this all the time. But if you're a judge adjudicating a case and thinking, like, I need to make some money, like, I'm going to retire in a year or 2 or 3, and you have a bunch of firms in front of you that are the place you're probably going to look for jobs, that might influence how you're going to adjudicate these cases. Now, again, this is a problem that's beyond judge shopping. It really goes to the entire federal judiciary.
Yeah.
But that's a reason a judge might want these cases in the first place. If you think you want to get in patent law, you want to track these cases so you can see the patent attorneys, they can see you, and you can become an expert in that.
Yeah. So the fundamental problem we're talking about, it's kind of twofold. So one, in the individual case, you're looking at potential miscarriage of justice, or kind of the scales being weighted a little bit. And then writ large, you're zooming out a little bit, you're talking about diminishing trust in the federal judiciary.
Yeah, I think those 2 things. I think the third one would be, well, let me say your first 2 are correct. Like, we don't want different outcomes because of a judge in a case. Like, that's just fundamental. We don't want that. The third one I'll say is the procedural aspect. Like, a lot of people listening to this, if they're not civil procedure nerds, probably think like, oh, procedure is, who cares? If you're going to change procedural rules, who cares about that? But for a lot of these patent cases and bankruptcy cases, I would assume, it's all about the procedure.
Big time.
Like, if I sue somebody, I'm not thinking like, oh, this is a good trial judge, right?
Right.
Because 2% of patent cases end up in trial. There's just nothing. Most of them are going to settle somewhere along the way. And so if I put a bunch of restrictions or make it easier for the plaintiff in that procedural world, I'm affecting 98% of cases. I really want that. If I'm just trying to settle and a judge has a bunch of rules which make it much more beneficial for me to settle than for you, that's a big deal.
Yeah. The bankruptcy equivalent would be What you talk about in the article are what you call drive-through bankruptcies. What we would call them typically are pre-packs. But basically, if you can get through bankruptcy quickly, and some of that does depend on how quickly a judge is willing to work. You can. We're talking savings like it can be 9-figure savings.
Yeah. And so, I mean, Apple, I always use Apple as an example because they get sued so often. Let's use Samsung so we can change it. But Samsung gets sued so often in East Texas that if they get sued there, they know about what their settlement is going to be. It's going to be $500,000. Not nothing for Samsung. It's easy to pay, but keep getting hit with those. It gets annoying. If I can somehow get into North California, that settlement rate drops to or amount drops to 200, 100,000. Either way, I just settle the case. But because of the procedural advantages the East Texas offers the plaintiff, I know that if I fight this, I'm going to have all these discovery things, all these summary judgment things, which are off the table from the Northern California. So I just have fewer chances to get rid of it, and so I have to settle for a higher amount. And so a lot of what's going on in the patent space is about how much these procedural rules impact the settlement on.
So you've talked about the wheel being a solution to this. Basically, in practice, what that's doing is just making it so people don't know for sure which judge they're going to get if they file in a particular district. What has been done to date, or what are some examples where a wheel was instituted? What happened to the caseload for those judges?
The two examples I'll talk about. One was in direct response to our article. Our series of articles.
Nice.
It was like the pinnacle of my academic career where.
It'd be famous at conferences.
Some
now.
senators read my piece.
They
wrote a bunch of letters to the chief judge of Western Texas.
And
they said, all these cases going to Judge Albright in Waco. He had about 25% of the cases nationwide at that time. They said, that's not a good thing. So either you do something about it or we'll do something about it. And then the next Monday, the chief says, all right, we're throwing this all patent cases in Waco are now put in a 12-judge wheel that might be in Waco, but might end up in Austin. And all of a sudden you saw patent filings drop. Didn't stop because a lot of people want Judge Albright, a lot of people want West Texas, but it went from 25% of cases to 7, 8. So that's a big drop. And so that's an example of if we made this rule nationwide that all courts and all cases have to have some randomization. Doesn't have to be perfect. But we think it has to be some randomization. That would just diminish the impact of judge shopping on forum shopping. So that was the first one. It was a huge success. I love it. I tout it to this day. Let me talk about the second one, which is not a success and a complete failure.
Okay.
Building on this, the judicial conference, the conference of judges made up of judges, chaired by the Chief Justice of the United States, sent out you have to careful how I characterize this, sent out a memo to all district courts saying, look, every nationwide injunction, and nationwide injunction is now subject to a lot of restrictions, but at that point they were a thing, including patent cases, has to be assigned among the judges of the district, not the division. So the division's a smaller part of the district. That's how one judge divisions happen. I think it's a great rule. I think all the judges should have done this. This would have really reduced judge shopping in general. Some judges, especially in the Fifth Circuit, said no. Great suggestion. We're not going to do it. And some district courts, like the Northern District of Texas, actually sent out a memo saying we reject the judicial conference's. They called it a suggestion. It was unclear whether it was a suggestion or a dictate or just a memo or what it was. And then in subsequent events, the judges of the circuit lambasted people like me who make these suggestions because we're politically motivated to make them. And it became very, very political very quickly. And basically this memo went nowhere.
Yeah.
And so the problem with not having this randomization across the judiciary is it leaves pockets like the Northern District of Texas, Eastern District of Virginia, of places where smart attorneys can use that to get the judge they want on their case. And that we think is just antithetical to anything that American jurisprudence has ever tried to do.
Yeah.
That is a disappointment. I was so excited because I didn't have any idea of the judicial conference. Well, I knew they were thinking about it, but I didn't know they were going to issue this. And that's probably why it didn't work. They didn't run it by the judges first. But I think this would have been a great change if it had been adopted across the nation.
Yeah. So this is not really a failure of the idea of the theory. This is just, all right, can we get people to adopt it?
Yes. So it's a failure of the memo sent out by the judicial conference. They could have said like, here, we're changing the rules of civil procedure so this has to happen.
Yeah.
Or there's just a memo saying it has to happen.
Yeah.
Or if they'd been more political and like talk to judges on different courts, I don't think this has to be political. I mean, I have my political preferences just like everyone else, but I don't think this is a political topic, and it should be something everyone agrees with. Everyone 5 years ago agreed with us that judge shopping is not good.
Yeah.
All of a sudden it's become very political.
Yeah.
And that is unfortunate, but I think there's still time just to say, all right, we're done with judge shopping. Let's make it illegal or restrict it somehow.
Yeah.
And then, forum shopping is still going to happen. This is still going to,
Sure.
You're still going to file your Prifestone case in Fifth Circuit, North Texas, West Texas, wherever it is. But just say you can't choose your judge. You can be there, but you have to randomly get a judge, just like everyone else.
Yeah. That's funny. This just reminded me, this is somewhat off. This is off topic. It's circling back almost an hour ago to something we talked about because it made me laugh and I wanted to bring it up. We were talking about how kind of how easy it is to establish venue in one jurisdiction or another. So that that's obviously true in patent cases. It's also very true in bankruptcy, but it's not unlimited, and actually be interesting to get your take on TC Heartland in a minute. But an example of where trying to get jurisdiction in bankruptcy went wrong. So this is governed by 28 USC 1408, and basically, large corporations tend to be made up of many different entities. And those entities will be organized under the laws of different states. And so, when we filed Endo International for bankruptcy, we filed 76 different entities for bankruptcy. A number of them were organized in New York, a bunch in Delaware, and then a bunch in different other jurisdictions, including internationally. But there's a 180-day look-back rule under 1408. And so if the only time you're ever going to get in trouble for that is it's a competence. It's a reflection of your attorney's competence or the board's obstinance. It was the NRA. They filed for bankruptcy in the Northern District of Texas in Dallas because they wanted the political advantages of being in Texas. But they filed in January 2021 after incorporating an entity there for the hook in November 2020, like 2 months earlier. Anyway, just dumb. But sorry, and that kind of we're taking it. So, I just thought that was really funny. I wanted to talk about it. Tell me about TC Heartland.
Yeah, so TC Heartland, there's a lot of history on that, but TC Heartland essentially made venue tougher to get in patent cases in certain districts, right?
Okay.
So the Supreme Court tightened up the venue rules, said no, venue's not synonymous with personal jurisdiction. It's just where you're incorporated, the defendant's incorporated, or where the defendant sells a product and has established place of business.
So what's interesting here, because you say that, okay, TC Heartland was 2017, right? And it was a unanimous decision. It was written by Justice Thomas. It's a short decision, relatively simple. I read it yesterday. so 8-0, yeah, Gorsuch, it wasn't yet on the bench to hear initial arguments. Judge Albright in Waco was appointed 2 years after that.
Yeah. I mean, Judge Albright doesn't exist without T.C. Hartland.
Interesting.
Because if T.C. Hartland hadn't happened, we would still have 50% or more of our patent cases in Marshall, Texas. Because of T.C. Hartland, it gave companies the option to pull out of East Texas, which they did. Amazon moved factories out of East Texas into Northern Texas or Western Texas. eBay moved a bunch of stuff out of East Texas because they were sick of getting sued there.
Yeah.
So they moved, and Judge Albright, who's in Waco in West Texas, for most companies, you can't pull out of West Texas.
Because West Texas includes
Austin, El Paso, San Antonio. So it's a much bigger market than East Texas, which is, Beaumont and
especially with
Marshall.
Austin being there is a major center for
Yeah. So it's an option to pull out of certain districts, to not have an established place of business.
Yeah.
But it's not an option in other venues. So the interesting thing about this case is, you're right, it was unanimous. I think everyone thought this was something that needed to be fixed. East Texas having 50% of patent cases is ridiculous. And they wanted to fix it. I think it's become complicated now as soon as other types of cases. So I'll use Judge Ho in the Fifth Circuit as an example.
Yeah.
He doesn't want the Fifth Circuit to not be the main place conservative issues are filed. He doesn't want the various judges in North Texas that are single division judges that you can choose. He doesn't want them not to get those cases for whatever reason. But that's what he's concerned about. And so if it were just patent cases, he'd say, fine, who cares where they go?
Yeah.
But now it's the abortion cases, gay marriage cases,
Right.
healthcare cases. All of them might go to Fifth Circuit or not. He cares about them.
Yeah.
And so that's, I think, the perniciousness of judge shopping. Once it becomes normalized, like, oh, this is something we can do to get these cases and decide them in a way, it just takes away a big part of the judiciary, of a thought of the judiciary as a neutral body that just hears cases and decides them.
Yeah.
Now it's about, this case was attracted to this district. That puts us in a terrible position. Let's settle.
That's really interesting. In part, because in patent law, you have the settlements and all that, but also with these political issues, we've been talking for a long time. Ironically, it was a big issue for the Federalist Society on the right for a long time, but this idea of judge-made law. Fundamentally under the Constitution, the idea is Congress, makes laws, passes laws, executive enforces, judiciary interprets, but for how you interpret can change what the law says.
Yeah, and we've talked about this. I mean, I want to be clear here. I don't think Judge Albright or Judge Gilstrap make bad decisions. I mean, like any judge, judge they do.
Yeah.
But I don't think they're on the whole bad.
Yeah.
I just think the procedural changes they've made to attract patent cases are bad.
Yeah.
The fact that they get 45% of cases is bad.
Yeah.
One person hearing 45% of patent cases makes them the patent judge. And that's not the system that Congress organized. And so I think that's one of the main problems with judge shopping. It just skews the incentives and the different voices that need to be in the conversation are excluded.
So last question, this is a mechanical one. So a judicial conference sends out the non-binding memo of sorts and is clearly in practice not binding, and the ones who don't want to pay attention to it don't. What would I actually don't know the answer to this. What would they do to make it binding?
Yeah, so there's a lot. I mean, we propose a bunch of solutions in the article.
Yeah.
Congress could do it in a second.
Okay.
But
they're
not going to.
Second. Yeah.
But if they did, it would be binding.
Yeah. Sure.
The judicial conference could make binding law, and so they do this in a couple ways. Civil procedure, changing the rules of civil procedure, just saying like district courts have to randomize the cases. period.
Yep.
Then that happens. Or this is a less likely solution now that it's been rejected. The Judicial Conference could say, we are sending out a binding memo to district courts that they assign their cases this way, like have some kind of wheel involved in the assignment of cases. That would be binding. District judges might freak out. They might say, this is stupid. They can say that. That's their right to do. But they would be bound by it.
Yeah.
So any of those solutions would work. I think the Judicial Conference option is the easiest, but it's the least secure. So I would like to see a change in the rules of civil procedure that would do it.
Yeah.
Or I'd love to see Congress get involved. And Congress has some interest, but they're unfortunately senators that are leaving. Senator Tillis was really invested in this. Senator Leahy from Vermont, who's now former Senator Leahy, they were really involved in following us and pursuing this. There's so much going on in Congress now. I'm not sure it's going to be the top. It's not going to be the tip of the sphere, but
maybe if you have a post midterms thing where they're kind of handicapped anyway. Maybe something you can get bipartisan. You'd get some bipartisan support for this.
Yeah, I think you would.
Yeah.
Now today,
sure,
but you wouldn't probably get enough. I think maybe what has to happen is pendulum swings back. Democrats start using this tactic. Both sides realize it's bad, but the problem with that is like they're in power.
Right. Yeah.
It's bad. Yeah, but we're in power now. Yeah. So there has to be some sort of meeting of the minds where they both say, like, you know what, enough of this. Let's do away with this judge hopping. It'd be really easy to do.
Yeah.
And whatever. Judges are political just like anyone else.
Sure.
Judge Ho's worried that the Fifth Circuit is going to be the choice of a conservative government case. I mean, they still are. They're still the most conservative. Yeah. They have the most conservative district court judges, most conservative appellate court judges. I just think they're going to still be the choice. The one difference that the wheel would make is like you might not be able to choose who the initial judge is.
Yeah.
And that makes a big difference in the outcome of the case because they can't point to that district court and say, look, he ruled this way, but he's probably the most likely to do that because he was chosen by the plaintiffs as the judge.
Yeah. It's interesting. The long run, hopefully, I don't know. If there's one branch of government in which we want people to have faith, just trust, I think it is the judiciary.
Yeah, and I agree with that. I also think that trust is what the judiciary runs on. As soon as they lose that trust, like no one trusts Congress, but there's still Congress. No one trusts the president, still the president. As soon as they don't trust judges, I don't think they're going to be used as much. And I don't think they're going to be able to enforce what they try to do.
Right.
We've seen that with, a lot of the deportation cases. Part of the judiciary's power is like in the ability of the other branches to respect them and just follow what they say. When push comes to shove, I actually don't have that much enforcement power. But I think that really depends on how much people think that they are neutral and that they're making not correct decisions, but fair decisions.
Yeah. Man, well, this was great. It's funny because this starts at a place where you're really into patent law, which is again one of the nerdier areas of the law, which is already a fairly nerdy area to begin with. And this was also fun for me. I've interviewed a lot of different people. Actually a disproportionate number of law professors, but of all the people I've interviewed so far, I think this was probably what I knew most about going in.
Oh, good.
Which I didn't know. From the title of the article.
You didn't know you knew about it.
Until I read the article. I was like, oh, man, this is right in my house. This is great.
Yeah.
So, Professor Jonas Anderson, thank you very much.
Thanks, Nick. It was a pleasure.
All right. And that was the interview. Thank you very much for listening. If you wouldn't mind, please do leave a review for the podcast. I believe those are important. And subscribe to the newsletter, which will be linked in the show notes, or can be found at neverclosetheinquiry.substack.com. Thanks.